Okay guys, so back again to the class sessions. Okay, I hope you sit with your case mats open, and as per the older case mat, it is page 219. Okay, that will be dealing with. So but then before we start, I really want that please it's a request guys, do comment that you like the class sessions better or you like the the note session better. Why? Because personally I do note session for the first years because I really feel that you guys might not be having an idea of how to write in exams, and one thing with law is that presentation really matters. All right, one thing is that Roscoe Pound really thought that the task of a lawyer should be to do social engineering, all right, to engineer the society. Now that is one thing, like that is because of the nomenclature that he chose, okay, engineering, and that too in a social context. So this is one thing that he has been criticized a lot. But before his theory is criticized, let us understand the concept of social engineering and what his theory proposes, okay? And this is the crucial and the main point that you all are going to write in the examinations, okay? So first of all, what was the aim of this concept? So the aim of this concept, I mean, if some of you were aware, it was given on the next page. So if not, do not go back, wait, okay, let me just revise it. So the aim of the social engineering was to build a social structure which is as efficient as possible, okay, meaning he said as efficient as possible means even he knew that somewhere the ideal and the perfectionism is just an idea which we will always yearn for, okay? We aspire to be idealistic, but eventually we need to what do we say, we need to consistently work for it, okay? So as much as possible there should be an efficient social structure. So that is what theory of social engineering was, okay? So for this purpose he said that how are we going to have an efficient social structure? So an efficient social structure can only be attained by dividing the interest of the people, okay, just the previous thing, classifying them, selecting them, and deciding the limits of the interest that has been selected and has been legally recognized, okay? So the one major point was interest. So now these interests were divided into three categories. One was individual interest, the other one being the public interest, and the third one being the social interest. So individual, public and social are the three kind of interests. Now these interests have subdivisions. Let's have a look at them. These are the claims or demands or desires involved in and looked at from the standpoint of the individual life, okay? One person, individual life, and what could his possible interests be. So these are further divided into personality, domestic relations, interest of substance, okay? Now ABCD karke diya hua, it is not very, so I'm just giving it a reading, okay? So personality includes that the physical person, freedom of will, honor and reputation, privacy, belief and opinion, okay? Domestic relations, as far as this is concerned, interest of individuals into a setup, into a social setup, like marriage, institution of marriage, institution of family, okay? These are the social setups that an individual grows in, okay? So the basic unit of society is a family. So domestic relationship with the parents, children, husbands and wives, all right? Now next is interest of substance. This says that this includes interest of property, freedom of industry and contract, promised advantages, advantageous relation with others, freedom of association and continuity of employment, all right? coming on to the next one, which is the public interest. So yeah, talking about public interest, the second one, this again has two categories. One as the interest of an individual as a juristic person, and the other one is the interest of a person in the as a guardian of social interest. Now the latter part, to a certain extent, it overlaps with the part 3, that is the social interest. We'll study it in detail, but then let's give a look to the interest as a juristic person. Okay. Now it says, these, as pointed out earlier, are not applicable in this country where the position of the crown has obviated the need for the personification of the state. Okay. Now we are talking about the common law system, that is where we are talking about the Great Britain. So he writes that where the crown is like, there's a sort of complete monopoly, where there is absolute autonomous sort of thing. So this sort of interest is mostly it's fading out from the people. Okay, so this is a contextual thing. You don't need to just know it, which is a very good thing if you know it, but do not write in exams, because 3 hours and you don't have much time to explain. So your answers should be very precise, point wise. Okay, and that explains what the question has asked. You don't need to write all the things that you know. You need to write the answer for the question that is being asked. Okay, now so this says these include the integrity, freedom of action and honor of the state's personality, and B, claims of the politically organized society as a corporation to property acquired and held for corporate purposes. Okay, so yes people, what have we done so far? We started with the popular movement, American movement. Okay, why was America so popular? Okay, and its comparison with Great Britain. Okay, why was America popular? Because the scholars over there were almost equal to the jurists. All right, however, in Great Britain, jurists were at a superior position comparatively. 1 point. Second point is that as far as common law is considered, as far as common law is concerned, the emphasis is majorly laid on the individual rights. And when the emphasis is made on, it is laid on individual rights, what do we need to do? We need to do 3 things, that is classifying the interests of the people, securing the limits to, like, the extent to which these limits can be secured by law, and then considering the means by which we can secure them. Okay, also he said that some social factors are to be considered. Okay, and when do we say that the social factors are considered while legislation, before a legislation is laid? Okay, and that is like those points, just go back, okay, check out the points, like something like doing a factual study, doing conducting a social investigation before you legislate, and these are the points that I can remember as of now. And what else? So, and then we come to his classification of interests. So he classified interests into 3 kinds, that was individual, public and social interest, and these were further again divided into the different subtypes. Okay, now what? Now so in a nutshell, let's study what is he trying to say, what is Pound trying to say. Okay, open your books onto the next paragraph right below the social interests. Quickly shifting to the books, these consist of the device. So what are the means? The means are 2. Okay, one is the device of the legal person, and the other is attribution of claims, duties, liberties, powers and immunities. Okay, that is 1 point. Second is there is also a redressal machinery, okay, which aims at, what is the aim? Now there is a consideration of means through which he can secure the interests of the people, which involves two things. One is the legal device, and the other is attribution to claims, duties, liberties, powers and immunities. Then the second point is there is a redressal machinery, okay, to redress the problem, to address the things, okay. And this aims, the aims of the redressal machinery, it changes as per the facts of the case, maybe, or like as per the circumstances, you can write, okay. Now this aims at punishment, redress and prevention, okay. So these are the three things it aims at. Next we have that what did Pound say? So he said that interests, he insisted, should be weighed on the same plane as it were, okay. One should transfer the interests involved onto the same plane, preferably in most cases to that of the social plane, which is the most general, okay. Now where he has said that interest should be preferably seen on a social plane, there is also a line wherein he says कि भैया interest classify कर दिए और उनको select कर लिया, legally recognize कर लिया, उसके बाद आपने चलो उसकी सिक्योरिटी, मतलब उसकी लिमिट डिफाइन करने के बाद उसको सिक्योर भी किया आपने, बट ये जो सिक्योरिंग ऑफ द लिमिट्स है ये किस पे डिपेंड करता है? ये डिपेंड करता है लीगल इंस्टीट्यूशंस पे, द नेचर ऑफ द लीगल इंस्टीट्यूशंस, ओके, इट डिपेंड्स ऑन देम. एंड what are the kind of legal institution? This is what has been told in the further lines, okay. So he, I guess, says 5 kinds of legal institutions, okay, please pay attention. First is which are percepts attaching definite consequences to definite factual situations, just like our IPC, definite consequences to definite factual situation. If somebody, I mean, IPC is a substantive law, so there are facts that if this particular crime has been committed, there is also a consequence for it, there is a sanction for it, that is कि फलाना फलाना अपराध के लिए, इन सारे offenses के लिए यही punishment होगी, okay. Next he says, secondly, there are principles which are authoritative points of departure for legal reasoning in cases not covered by rules, okay. Just in case you don't have a legislation for a particular offense, then what happens? There are, or like we don't know, the law is ambiguous, it is not clear about it. So what do we do then? Then we go for the principles, like principle of natural justice. Thirdly, there are conceptions which are categories to which types or classes of transactions and situations can be referred, and on the basis of which a set rules, principles or standards becomes applicable. Limitation law, I guess it can fit in this one, because there are categories to which types and classes, as in like if a definite period of time has been passed, you cannot come to the court and just say कि नहीं अभी वो 25 साल पहले का प्रॉपर्टी पड़ी है उसको दोबारा होगा, you can't do that, okay. Next is there are doctrines, okay, which are the union of the rules. What are doctrines? These are the union of rules, principles and conception with regard to a particular situation or types of cases, okay. Finally, you have the standards prescribing the limits of permissible conduct which are to be applied according to the circumstances of each case. So in case you guys are wondering that why I did not cover the social institute wala system, so okay, getting back on it, general security, okay, this embraces those branches of the law which relate to general safety, general health, peace and order, security of acquisitions, security of transactions, okay. The next one is social institutions. So this social institution, now any, like if I say a family, it is a social institution, so it considers again 3 things, like religious institutions, domestic institutions, political institutions and economic institutions. So these are the social institutions and their security is considered, okay. And the next one in the line is the social interest of the security of the general morals. All right, so what do we have here? The claim or want or demand involved in the social life in civilized society to be secured against acts or courses of conduct offensive to the moral sentiments of the general body of individuals therein for the time being. Okay, now it is very, very important. Something like, if any of you has gone through the judgment Ayodhya verdict, okay, it says that at just the second last paragraph, that on the basis of faith and belief of the people. Okay, so no, there is just an example. So on the basis of faith and belief, so at times the security of the faith and belief of the people and the conduct of any person should not be offensive to society as a whole. All right, examples such as, like, I just related it because I think I'm accustomed to relating things as a law student and as a lawyer, but just try and connect. So open your brains. Social interest in the general security. Okay, then you have social interest in the security of social institutions, and then you have social interest in the general morals, and social interest in the conservation of social resources, social interest in general progress. Okay, and the last one is social interest in individual life. Okay, now, and this has three aspects. Like, just shift to the the second paragraph of your text, and it says this has three aspects: economic progress, political progress, and then is the cultural progress. Okay, so this has three aspects, and the three aspects are again further divided into subdivisions. Okay, refer to your text. Okay, and one of them being cultural, political, and economic progress. Okay, so, and then comes the social interest in the individual life. Okay, which says that the claim or want or demand involved in social life is in civilized society that each individual be able to live a human life therein according to the standards of the सोसाइटी. ओके, इसका बस हिंदी अनुवाद कर देती हूँ मैं कि हर एक व्यक्ति समाज के स्टैंडर्ड के हिसाब से ओके जिए. दैट इज़ अ पर्सनल अर्निंग की ओके एवरीबडी शुड हैव गुड अर्निंग, you see, good things in life. Yeah, so, and it involves self assertion, opportunity, and conditions of life. Okay, club this and give it a recall again. We started with the American movement, okay, and how the jurists and the scholars in America and Great Britain are treated, like औकात क्या है उनकी. Okay, next is the point of what happens when you are legislating, like why is it important to consider the social factors, because only then we can check the effectiveness of the law, only then we can build a very, very efficient social structure as far as possible. So there are some points which says like you need to recognize the limits and classify the interest and securing the interest, okay, by law for those things, and you need to socially investigate before you legislate, and a lot of things. Okay, only then it can be said that yes, you have checking out on the legal history. So only then you can say that the social factors has been considered. Then we come on to common law system, and we discuss a bit about it, that it considers individual rights, and then we have what do we call? So as far as common law system is considered, it is the recognition, defining the limits, and then again securing those limits. And then we shift to classification of the interest, which is again 3, and they are again further divided. Okay, so and then it is said that, you know, interest should be preferably seen on the social plane, and for this you have, you know, different means, and which consists of the, you know, attributions of claims, duties and immunities and all. And then further there are 5 kinds of legal institutions that serve to secure these interests. Now we'll finally shift towards the end part of the sociological school of jurisprudence, which is the criticism.